Okay, well, so as not to waste too much time, because we do only have an hour this evening, for those of you who are in the United States side of things, I guess it's morning time for you. So firstly, I'd love to say welcome to everyone. I'm looking at the participant list and I'm already full of smiles with all the names that I recognize, but also quite upset that I cannot be seeing everyone in person, because this would obviously have been such a great event to reconnect with everyone face to face. But I will say it's also a great feeling to just be in the same virtual room as everyone. We've all kind of been in our Zoom cocoons for the past year plus. So it's really fantastic to just see so many familiar names and faces. So what I would like to do is firstly, welcome to everyone. Um, Today is bound to be a very insightful hour, I think. And in this hour, we'll be discussing Dr. Julie Fraser's book, published by Cambridge Press, titled Social Institutions and International Human Rights Law Implementation, or what I like to call Every Organ of Society. I think that's such a catchy title. But it's my absolute honor to be able to chair this very special occasion for not only my colleague, but my really good friend, Dr. Julie Fraser. By way of introduction, my name is Stacey Links, and I'm a South African researcher and lecturer based at Leiden University here in the Netherlands, where I teach in both bachelor and master's courses at the Leiden Institute for Area Studies. Now, my own background is actually in the intersections of international relations and international human rights scholarship, particularly insofar as China-Africa relations are concerned. And in fact, to give some context, Julie and I did our PhDs together. And so I take this moment and this occasion of the launch of her book as also a very proud moment for myself. I actually received the book in the mail this morning and I was beaming. It's really spectacular to actually have it in your hands. But today I do want to put the spotlight on the person of the hour, which is Julie Fraser. For those of you who don't know her, our author today, Dr. Julie Fraser, is an assistant professor with the Netherlands Institute of Human Rights at Utrecht University, also here in the Netherlands. And she completed her PhD in 2018. And as part of her doctoral research, Julie actually assisted the UN Committee on the Elimination of Discrimination Against Women with their 65th session in Geneva in 2016. And she also undertook field research in Java, Indonesia in 2017. I remember being quite jealous that she was able to go do field work in Indonesia. Her PhD was awarded the Max van der Stoel Human Rights Award in 2019. And Julie currently teaches in both the bachelor's and master's programs and has given guest lectures and presentations on a wide variety of topics worldwide. Alongside her doctoral research, Julie was also or acted as the managing editor of the Netherlands Quarterly of Human Rights for 4 years, and as senior counsel with the Public International Law and Policy Group, a pro bono global law firm. Prior to academia, Dr. Fraser practiced law as a qualified solicitor, including with the Registry of the International Criminal Court and with the Australian government solicitor. So we really are honored to be able to have Dr. Fraser's work in our hands finally, and to be able to get an insight into her brilliant mind. Second up, and as discussants today, we are very privileged to have two outstanding professors in our midst. Firstly, we have Professor Alison Renteln, who is a professor of political science, anthropology, law, and public policy at the University of Southern California, where she teaches law and public policy with an emphasis on comparative and international law. A graduate of Harvard. She has a PhD in jurisprudence and social policy from the University of California, Berkeley, and a JD from the USC Gold School of Law. Her publications include The Cultural Defense, Folk Law, Multicultural Jurisprudence and Cultural Law, and Global Bioethics and Human Rights, and numerous articles, of course. So she's not new to the game. She has taught judges, lawyers, court interpreters, jury consultants, and police officers at meetings of the American Bar Association, National Association of Women's Judges, North American South Asian Bar Association, and the American Society of Trial Consultants. Renteln has also collaborated with the United Nations on the implementation of the Convention of the Rights of Persons with Disabilities, lectured on comparative legal ethics in Bangkok and Manila at ABA sponsored conferences, and she has also served on civil rights commissions and the California Committee of Human Rights Watch, or the California Committee of Human Rights Watch. So welcome to Alison. Our second discussant today is Professor Ann Skelton, who is a fellow South African. Professor Skelton has worked as a children's rights lawyer in South Africa for over 25 years, where she played a leading role in child law reform through her involvement with the committees of the South African Law Reform Commission that drafted the Child Justice Act and the Children's Act, and was also the director of the Center for the Child Law for 10 years, and initiated strategic impact litigation work. She currently is a law professor at the University of Pretoria, the UP, where she also holds the UNESCO chair of education law in Africa. She's an internationally recognized researcher and has published widely on children's rights, education law, and restorative justice. Now, in addition to teaching child law and education law at UP, she teaches international children's rights in the Masters in International Human Rights Law at the University of Oxford. She's also a visiting professor of the University of Strathclyde and is the holder of the rotating honorary chair of the enforcement of children's rights at Leiden University. She's an advocate and has appeared as counsel in many landmark child law cases in South African superior courts, including 12 cases in the Constitutional Court. Her awards also include the Honorary World Children's Prize, presented by Queen Sylvia of Sweden in 2012, and the Juvenile Justice Without Borders Award, presented by the International Observatory on Juvenile Justice in 2017. She is currently an international ambassador for the British Society of Criminology, and since 2017 has been a member of the United Nations Committee on the Rights of the Child. So I would like to welcome our distinguished guests. It's really a pleasure and a privilege to read out bios like that. Makes me think I still have a long way to go. But welcome. And I'm sure that as discussants, both Professor Renteln and Professor Skelton will provide quite a few insightful comments and points for discussion, rather. But to get into today's proceedings and why we are actually all here, let me say a few brief words about Dr. Fraser's book. Those of you who are here no doubt have taken an interest in the book's contents and Dr. Fraser's work, and like many of us have eagerly anticipated the official release of it. This book is not only timely in a world where we see the challenges of human rights, globalization, and localization, but it's also timely as we witness a kind of confluence of cultural and ideological contestations around issues of human rights. Of course, these are age-old challenges and not particularly new. However, the current geopolitical, economic, and social context is, for a variety of reasons, unlike any other. And this context that we find ourselves in has raised significant questions and challenges that all require concerted efforts from multiple stakeholders in ensuring the protection of human rights is maintained, and that it's maintained a priority, and that it maintains legitimacy worldwide. So Julie's work is equally apt at a time when there's increased recognition, both within academia and policy, for example, for efforts to decolonize international law, or rather focus on the limits of absolutes such as the law, recognizing not only the limitations of law, but the richness of social institutions, for example, in effectuating change. And Julie's book demonstrates this very, very well, and is a paramount contribution to the continued legitimacy of human rights worldwide. What I'd now like to do is give the floor over to Dr. Fraser herself, and she's going to tell you a bit more about the book, after which I will hand the floor over to Professor Renteln for her insights for about 10 minutes, and then Professor Skelton will give us her insights and discuss elements of the book for approximately 10 minutes. After that, we'll open the floor for questions from all of the participants, and really take this time to jot down some questions for the discussants and or for Julie. What we can do when we open up for discussion is, because we've been in such a virtual world for the last while, I would encourage you to raise your hand and to ask your question via your computer or your device directly to whoever it is directed at. And for those of you who are a bit on the shyer side, there's always the chat, so I will keep my eye on the chat. But for now, I will hand over to Dr. Fraser to give us an introduction of her book.
Thank you very much, Stacey, for that introduction. Thank you, everyone, of course, also for being here. I fully echo Stacey's comments about wishing this could have been done in real life. The book was actually published in August last year, but I held off on holding a launch because I was hoping to do it in person. But there are certain benefits also to doing it online, of course. So I'm really pleased to be here with all of you, and thank you for your time and your interest. This book, as Stacey mentioned, came out of my PhD research, and the beginning point for that was really the fact that there's such still poor realization of human rights all around the world. And I saw this fact as being connected in part to their continued cultural contestation. And that applies both here in the Netherlands, but also my home country in Australia, as well as all the other countries in between. Stacey mentioned as well that human rights are no stranger to contestation. From when they were originally drafted after the Second World War, of course, there was contestation and debate. During the Cold War, of course, that was continued along the divide between civil and political and economic, social and cultural rights. In the 1990s, then it sort of opened up, but then we also had the Asian values debate, also then feminist critiques, then increasingly post-colonial, and now, as Stacey also mentioned, decolonial critiques. And of course, in the last decade, we've also then seen a backlash on rights and international multilateralism, particularly also in the West, which was sort of seen as the typical cheerleaders for this international system of human rights. So I don't necessarily find contestation problematic per se. I'm happy for there to be this dynamism and this debate around human rights, but I do think that the fact that it undermines the enjoyment and realization of human rights to be problematic. And so in the book, I suggest that some of the work we still have to do relates to these two particular key issues. One, the cultural contestation, but also the legalism and state centricity of international human rights law. And legalism is this idea that human rights are legal claims, that they're enshrined in legislation, protected by the courts, as well as in the idea also that human rights problems can and should be solved by the law. This is, of course, not the case. Lawyers do not have a monopoly on rights, nor does the law. And I say that, of course, as a trained lawyer. But my critique here is then also of the UN treaty bodies, because in my view, and as the research in the book has shown, they are overtly legalistic in their approach to human rights. And you see this in terms of the concluding observations, where they very frequently default to recommending state legislative measures, and also then to the role of courts in enforcing those laws. And this is even done in times when it will be ineffective, where the laws won't be implemented, or when it could even cause a backlash. And in my research, I gave an example of this from Indonesia, where there was a law that was passed by the government in relation to female genital mutilation or cutting or circumcision. And in response to that, there was such an outcry domestically in Indonesia that in fact the law had to be withdrawn. And a similar example I've just come across also in relation to a study that was done in Jordan was in relation to the CEDAW committee, also where they urged Jordan to withdraw the reservations. And Jordan did so, but there was such huge backlash then domestically that there was in fact a fatwa given against these lifting of the reservations, and then calls for Jordan to in fact withdraw from the treaty itself. So I think this sort of example shows that in fact these legislative measures can sometimes be very counterproductive to the protections that we are actually trying to realize. So as I said, I myself am a lawyer. I'm not necessarily saying we dispense with the law, but rather we dig around a little bit more in the toolbox for also other complementary or supplementary mechanisms that can be helped to realize human rights. And one of those is also drawing from a lot of the scholarship by Alison Renteln and other such colleagues, looking also at anthropological ideas and ideas about legal pluralism. So also taking a broader understanding of what law is. So it's not just positive state law, but it's also different types of law above and below the state itself. So in this argument, also looking at legal pluralism, you also bring in other actors that relate to these other legal norms. And so this is where I also say, while we need to also consider norms beyond the state, we need to consider actors beyond the state. And this is the quote that I take from the Universal Declaration of Human Rights, which is in the preamble that talks about every organ of society having a role to play in the realization of rights. And so I hark back to this quote already from 1945 and say, we've come quite a distance away from that. And the treaties really pushed this sort of legalistic approach that really focused on the state. And I'm suggesting here that maybe we can go back and re-engage some of those other social actors, in this case, social institutions, to help realize human rights. And again, my study then looked at what the treaty bodies did in relation also to these non-state actors. And again, it finds that the treaty bodies, they're also bound by the text that they work with, of course, but they also very much focus on state actors, and at times also seem to completely marginalize non-state actors. Now, some treaty bodies do it more than others, but for example, in relation to my study on Indonesia, the Human Rights Committee and the Committee monitoring the International Covenant on Economic, Social, and Cultural Rights, in their discussions with Indonesia regarding implementation, they do not mention Islam or the Muslim community directly at all. And I find this quite striking, of course, because Indonesia is the country in the world with the world's largest Muslim population. And in fact, the CEDAW committee and also the Committee on the Rights of the Child do better in recognizing other norms, other actors, and the central roles that they play. I also go a little bit further. That argument doesn't necessarily challenge the structure of international law as it is today. But I do want to actually still push international law and step into this bigger debate now about the state centricity of international human rights law. And that gets into the contemporary debate right now, of course, about extending obligations directly to non-state actors. There is, of course, a draft going on right now for a treaty on business and human rights that looks at the ways in which human rights might also extend to businesses particularly. And there was, of course, in The Hague, a recent decision where the court actually essentially applied the Paris Climate Agreement to Shell, a non-state actor itself. So you can see that the law is really shifting, and that's also in response to the challenges that we have today. And I think for human rights to remain relevant and for them to be important norms, they do have to stay up to date and stay relative to the challenges that we see before us. So I put this in the book. I am very pleased that you have all taken up some of these topics, and I'm really interested to hear, Alison and Anne, your comments and your reflections on this as well. Thank you.
Thanks so much for that, Julie. Really great to hear the summary of the book from your perspective. Alison, I'm going to hand over to you for your points and comments.
Thank you. It's a great pleasure to help celebrate Dr. Julie Fraser's magnificent book. I've learned a lot from her. She is a generous colleague and really a rising star. And so I'm so pleased to be here also on this distinguished panel and among so many human rights scholars and activists and judges whom I admire. This is a splendid book, has a beautiful cover. I wondered about the significance of the design provided by David Feen. I guess there's not an image of a person, so that's culturally sensitive. But I wanted just to make a very few brief comments about the book, about the theoretical framework, the empirical investigation, and the recommendations for policy changes. So Dr. Fraser's theoretical framework is compelling for several reasons. She recognizes that culture is dynamic, and she, throughout the book, emphasizes that we ought not to demonize culture as being necessarily static and negative. I think that's important because it's so common for writers and advocates, I think, to misconstrue culture and assume that all aspects of it are negative, which is obviously false. In her consideration of human rights, she provides a nuanced treatment of concepts. And I think what really strikes me is how beautifully written it is, but also it shows what a careful thinker she is. She accurately characterizes the positions of other scholars. She reads their work closely to make sure she doesn't misrepresent their arguments. So she treats cultural relativism as a descriptive theory and recognizes that this debate about relativism versus universalism, while people wish it would go away, is still reflected in current debates in the United Nations, for instance, around, quote, harmful traditional practices. So people often talk about we're in the post-relativist era, and maybe that's wishful thinking. A second reason her theoretical framework is so compelling is that she rejects the state-centric approach or the positivist approach to implementation. And she makes very clear the importance of studying other institutions besides legal institutions. The book itself does examine closely treaty bodies to see how they handle these questions, but she urges scholars and others to take into consideration non-state actors and various social institutions. And so among those, I was trying to think of all the different ones that we could add, like universities, gaming, media. I think Dr. Fraser mentioned celebrities and foundations, development agencies, and then the important role of human rights cities, which I know some Dutch scholars, Dr. Oeman's work is very important in that area, and then businesses, as was just mentioned. I'm not sure that one has to embrace legal pluralism to encourage scholars to look at these other ways of enforcing human rights, because they're also part of teaching people how to think about human rights. But I think certainly people in legal pluralism would embrace that approach. But I think that your approach will appeal to people who don't identify with that intellectual movement. I do think more could be said about customary law insofar as it influences not only courts, but also these other organs or social institutions. And then another reason why I think the theoretical approach is important in her book is the way she argues that religion and culture can in fact be helpful in leading communities to embrace human rights. She says on page 269, quote, "Religion can be an ally in human rights implementation. Religion, as well as culture generally, should not be ostracized or worse, demonized in international human rights discourse." So her main argument that we should take a culturally sensitive approach to the protection and promotion of human rights is certainly compelling. I couldn't agree more. As to the empirical work, it's really incredible that she conducted so many interviews. I wondered about how that was organized. Were there interpreters? How one would get informed consent? Were pseudonyms promised? It's really a remarkable social science that's in the part of chapter 5. I wondered if Adat law was part of the conversation. There was much more emphasis on Islamic law, which is thought not to be implicated in FGM, but certainly a very impressive social science. And I could go on, but I don't want to take too much time. So finally, on the third issue of policy recommendations, Dr. Fraser notes that a major concern is the large gap between human rights treaties and their enjoyment and practice. And I think she's urging us to look carefully at that. She doesn't avoid the treaty bodies. It's not just that we need to get human rights in the hands of the other social organs. She suggests we might pay more attention to the composition of the treaty bodies to make sure that there are people acquainted with the folkways and religious law and so on. And she discusses the interpretation of culturally appropriate methods of implementation, policies that she uses the Committee on Economic, Social, and Cultural Rights as an example of that. And I think that was very clever maneuver of hers. And she, as I've said, and it's clear, the main thrust of the book is to shift our attention to having human rights incorporated in the functioning of other social institutions. So I just thought that there were a lot of sort of practical policy implications that come from the book that will appeal to people in the UN and around the world who are seeking ways to support cross-cultural legitimacy of human rights in a more practical way. And I think one of the parts that's of concern and it gave me pause and I'm still kind of pondering is this idea of backlash, that there are so many well-intentioned people who want to promote human rights, but it often comes across as cultural imperialism. And so how is it that we can be scholars, teachers, and advocates of human rights and be more sensitive of the way we're coming across as being arrogant, what words we use, knowing languages that help us communicate with people, in finding these kind of equivalents in different societies or analogs to avoid this kind of backlash. So anyway, I don't want to take up any more time. I just want to say this is a magnificent study. It's eloquent. It has nuanced interpretations of very complex theoretical ideas and very subtle analyses of cultural forms. It advances a compelling argument that we rethink our approach to the implementation of human rights standards. And it was certainly a privilege to read this important book that will be a classic in the field. Congratulations.
Fantastic. Thank you so much, Allison, for those insights. I'm just thinking to myself even more now how I am missing the fact that we don't have drinks after this face-to-face. I'm now going to hand over to Professor Skelton for her insights and reflections on the book.
Greetings, everyone. If there's one thing I absolutely don't like about international human rights law, it is the absolutism of it. I'm delighted to have been invited to talk about Julie's book. I've learned a lot from it. And I'm here really to share, I think, some insider information about being on a treaty body and how some of the conversations go there. So sitting there, I hear and I read many absolute statements about rights, and I find that there are limited opportunities to really debate any of these issues. Now, coming from South Africa, I was surprised to find that the Committee on the Rights of the Child took such a strong and uncompromising position on polygyny, for example. Now, I knew this before I joined the committee because the concluding observations handed down to South Africa in 2016 strongly urged South Africa to outlaw polygynous marriage, which was a bit embarrassing, seeing that the president at the time was himself in a polygynous marriage. And I knew that this had not come from the civil society organizations who had reported to the committee. They hadn't raised this as a concern in relation to children's rights. So therefore I knew that it came from the committee itself. So when I joined the committee in 2017 as a newbie member, I tried to raise this issue and I asked whether we were basing this position on research about the effects on children of polygynous marriage, because after all, we are the Committee on the Rights of the Child. I was given pretty short shrift by my colleagues, even including female Muslim colleagues, who told me that this was very settled in international law and it really didn't need any further discussion. So, you know, I am a lawyer and a litigator, so in some ways I am quite attracted to the clean contours of law and legal argument, and bright lines can be quite pleasing, right? It seems easy. But of course, the world is a very messy place. And when you start trying to actually apply this to real people's lives, that's when it gets tricky. And so it was that I came across Julie's writing that captures all of that so very well. In 2019, I was doing a guest lecturing stint at Leiden, and I was teaching enforcement of children's rights. Now, just the very title of that course, you know, sounds pretty coercive, doesn't it? You know, enforcement. Children's rights. And so, yes, it does drive a pretty strong agenda around using the law and, you know, seeing the state as having obligations and holding them accountable. But also built into the idea of the course is this idea that non-state actors can and must also play a role in the enforcement or implementation of children's rights. I have no doubts about this because I've worked in civil society for most of my life, and I know how important civil society members are in the implementation of rights. But looking around for academic inspiration on this, I found Julie's article, Challenging State Centricity and Legalism, published in the International Journal of Human Rights. And at its heart was this Indonesian family planning case study that also features in this book. So I was very excited by this article. I was really quite blown away with it, and I immediately set it for my LLM students. And we had some great debates talking about what a great example this was, but what did we think, what did we feel about those adolescent girls who would not be reached by the government's family planning approach because they were unmarried, and the way in which the work with the Muslim leaders had worked out was that only married people would be able to get the right. So, you know, it was a very rich discussion and very exciting. And subsequently, I met Julie, traveled to Utrecht. It was a very rainy day, I remember. I want to come back when it's not raining. And this year, she joined me again in that LLM class to unpack the Indonesian case study with the students. And I must say, it makes for great debates and very good for law students to think about some of these issues. So I've now had the opportunity to read through the theoretical context of the case study in this book. I must say I have learned a lot. I really have. And I found the book also immensely readable. You know, very often when a book grows out of a thesis, a doctoral thesis, it can be rather difficult to read and dry, but not this one. And maybe that's because partly of its interdisciplinary, multidisciplinary nature. It seems to have something to say to everyone who might be interested, everybody who wants to listen, and it draws the reader in. It draws me in because it focuses on the art of the possible, about what we can really do. It doesn't shrink from controversy, but it calmly charts a way through. And ultimately, it deconstructs, as is now, you know, very much what is being done by scholars everywhere, but it does it in a very constructive spirit and in a way that makes me still feel a little bit hopeful that the Human Rights Project can go forward, albeit that we'll have to go forward looking at it in a different way. So I think it's a very fantastic and important book, and as has been said, it is also a very beautiful book, good to have on your shelf. So I urge anyone who hasn't read it yet to do so immediately, and I want to say congratulations, Julie, well done. This is really a fantastic read, and I hope that many more people will read it.
Oh, fantastic. Thank you so much for that, Anne. Absolutely lovely, lovely reflections. Even I'm beaming with pride. So thank you. Thank you so much for that. I would love to open the floor up now to the participants who are here, who may have some questions. We don't have any questions in the chat, but as I said earlier, if you have any specific questions, please do raise your hand and we can hand over the floor to you and introduce yourself, and please feel free to ask a question to any of the panelists, that is. I'll give you a minute. Okay, we have a question here from Divya. Divya, the floor is yours.
Hi.
Please unmute yourself and
Am I audible?
Ask away. Yes, you are audible.
Okay, great. Thank you for arranging this beautiful book session. I have not got my copy yet. I definitely hope that I'll get it soon when India opens up. I do practice in Indian courts, specifically in Supreme Court and High Court. So I wanted to ask Julie as in if she is planning to do anything with Indian data available for human rights issues, since you have been writing so much extensively in this book about Islamic rules and related to Indonesia and all. First question is that. Second is in relation to your reference to legal pluralism when you were talking about it and how to make it help realize the human rights. Could you just emphasize on that a little bit more? Keeping context a little bit different from the demography which you have taken, maybe regarding India, or if possible. Thank you.
I think you can answer that directly, Julie. And in the meantime, if anyone else has a question coming up, please do raise your hand so that I can take note of that.
Thank you, Stacey, and thank you, Divya, for being here and also for your question. I take your comments as an invitation to come to India. I would be thrilled to take you up on that. I've always wanted to go, but I've never been, so we'll have to plan to do that as soon as travel is again possible. I did a little bit of study about Indian laws and also use of customary law for another article that I wrote with a colleague on legal pluralism. So I would love to come in and look at some of the different norms that are applied in India, because I think it's also very, very rich in terms of the different norms and how they are applied. Obviously also big Muslim population in India. So I think some of the Islamic norms could also be interesting to do some comparative work there. In terms of coming to India, as I said, we'll have to schedule that one in the calendar. And in terms of legal pluralism, obviously, you know Indian norms better than I do. But one thing that always struck me in the research that I did in relation to Islam was a quote by Rifat Hassan that I use all the time, where she talks about the fact that rather than using UN norms, it's much better to say to Muslim women that the Quran supports their rights to reproductive health instead of telling them that a UN document will set them free. And I really like this because I think it also shows the connection, the familiarity, the trust, the legitimacy in those local norms as compared to the international ones, which are often just completely unknown in most domestic settings. So this is where I think that legal pluralism can be really beneficial when you rely on those local norms that do have legitimacy, they are trusted in the community, there's also ownership within the community, and they can be much more powerful and meaningful than these international ideas that are lacking. So this is where I see legal pluralism being beneficial, both in different parts within a state and across states as well, certainly in terms of Islamic law. Thank you.
Great stuff. Next up, I have a few questions in the chat, but I'm first going to turn over to Professor Serge Gamga, who has a question for, I'm thinking, Julie. The floor is yours.
Thank you, Stacey. And I use this opportunity, first of all, to congratulate Julie and thank you as well for bringing this impressive panel, including Stacey as well, who is not only the facilitator, but who is also a great scholar in this particular field. I find the book to be very revolutionary in my view, because you question the so-called norms. You question what it's universally accept as the legal, what the law must do. Bringing it every organ of the state, looking at institutions, the role of social institutions. In my view, it's very innovative and very applicable to the African and South African context. My question, although my question is to Julie, but I'm sure Anne can also respond to that question, and even you, Stacey, because it's a bit contextualized with the South African situation. In a place where legalism is known as the rule, even though there is customary law, we know in South Africa, we are very proud, we are very proud to be saying our constitution is one of the best in the world here in South Africa. However, when you look at the level of xenophobic attacks, and the court so far has not been able to deal with the issues, to what extent can social institutions that are very strong, like traditional leadership institutions, can play a role in complementing legislative efforts in dealing with the question of xenophobia in South Africa? That's my question. Thank you. Congratulations again, Julie.
Fantastic. Thanks so much, Serge. I'll hand it over to Julie, and perhaps Anne even has some insights into that lovely question.
Thank you, Stacey, and thank you also, Serge. It's such an important topic. I think it's not just South Africa. Also in Australia, we have a lot of issues with xenophobia, and our migration policy also for several decades now is quite appalling. Of course, in Europe as well, we've had the refugee crisis also now for, 6 years or something. But of course, the problem's been a much larger time than that. And I think it's really important to look at social institutions in all of these different countries to see how we can actually address that problem and apply human rights norms to those people so that they can realize their rights. I'm also better posed to answer that question in terms of Australian social institutions. So this is where I'm going to pass over to Professor Skelton, and Stacey, you also with your domestic knowledge.
Yes, it's an interesting question. Thank you, Serge. I mean, I do think about, for example, the churches. And interestingly enough, the churches are, a number of years ago, I worked with a group of migrant children who had come to Johannesburg and were living in the Central Methodist Church. And it was interesting to me that they had fled from their countries and they knew they were coming to that Central Methodist Church because they had heard that it was a place of refuge, a place that you could come to. So certainly one can already see that there's a connecting point there, and perhaps that's that's a conversation that needs to be developed into something much bigger to think about how religious communities might be able to do more. Certainly, I think the government itself in South Africa pays lip service to this, but I mean but I agree with Serge that it doesn't seem to be really sinking down. So that is a challenge, and I think we do need to do some thinking about why that is. And even though we have South Africa's history when, during the apartheid years when so many South Africans went to neighboring countries, why is it that isn't being paid forward, as it were? Maybe Stacey has some ideas.
Fantastic. No, I agree with what both you and Julie have said, and the issue that Serge has raised. And it has to do with this worldwide phenomena of us versus them mentality, in group, out group dynamics. And I think that's probably one of the largest issues or foundational issues that human rights protection actually faces is how to transcend what is arguably a very natural or inherent characteristic of human society to a certain degree, where groups seek self-preservation, arguably, right? And so, of course, I have no answers for this, but this is something that I definitely, that is on my mind quite frequently, and the interplay of these narratives with also the political, right? So the securitization of refugees or the other, and how we can actually bring the other in such a way so that the other is no longer something distant out there and scary, but something that we can dialogue, or groups or people that we can dialogue with, and have differences, but be able to still live in respect of their human rights. Yvonne Donders has her hand up, and she's had it up for a while.
Oh, no, don't worry about it. Thank you so much. Well, good to see you all, first of all. Nice to see some familiar faces. So first of all, congratulations. And that's why I mainly took the floor to congratulate you, Julie, with this wonderful, wonderful book. And as you know, it has been a real pleasure to supervise your PhD together with Tom Zwart, who's also here. So it's great to see how the book has also become even better than it was already when you defended the PhD. And I really concur with what is said about the readability of the book. Already your PhD was quite readable, but actually, the fact that you can reach such an audience with this complete complexity of issues is a real asset to the book. So I'm very proud. And what I found so interesting in your work, and still find actually, is that you really took several human rights debates further. First of all, indeed, the debate on universality and relativism. You really went beyond the description of the two sides and overcoming the dichotomies, etc. You really took it to a different level, and I think that's really worthwhile reading for a lot of people. The second debate that you took further is indeed the one on non-state actors and their importance in not only violating, but also implementing human rights, and what that role could be. So that's another where I think your book is extremely relevant. And finally, and that's what my question is going to be about, is the role of the treaty bodies and the role of international monitoring, perhaps a bit more broadly. Because I'm wondering, and also listening to the fascinating example that Professor Skelton was giving on the CRC, I was indeed wondering, don't we sometimes expect a bit too much of these treaty bodies? And I'm also looking at Professor Flinterman, of course, also as a member of two committees, actually, or former member of two committees, CEDAW and the Human Rights Committee. Because is it feasible, doable, maybe it's desirable, but is it feasible and doable for a committee to actually grasp indeed those dynamics of cultures that are existing in, again, some of these huge countries also, the one you're talking about is Indonesia, which is a huge country with internal divisions as well, regional differences. And as we started with, cultures are dynamic. I think that's a very good recognition, but how can a treaty body, with all the limits that it has in terms of timing, in terms of funding, in terms of not having that much time to reflect on all of these things. So they're quite dependent, I think, on what is brought to them. And then, of course, your example, Professor Skelton, is fascinating. And I completely agree with you that it's completely strange that the committee takes a route on a certain topic without even having to be presented with evidence that that is a problem actually in the country. But I also see, and also from later research by Vincent Vleugel, for instance, Julie, that these treaties bodies are struggling with these things because it's not easy to get yourself around all the complexities of these things. And do we not sometimes expect a bit too much from them, even though, of course, I completely agree with you that they should involve these social institutions more. But of course, their possibilities are limited. So perhaps some of you can reflect a bit on that. I would appreciate that. Thank you very much. And again, Julie, warm congratulations.
Go ahead, Julie.
Thank you very much, Yvonne. Thank you for being here. Also, Tom, as well. I have to do a shout out to my supervisors. And Yvonne, yeah, I was really concerned in doing the research to make sure that my recommendations were going to be feasible to some extent. I'm an idealist, but I did want them to be somewhat feasible. This was partially why I also went to Geneva to work with the CEDAW committee to make sure that anything I recommended wasn't going to be completely implausible from the committee's perspective. And that was hugely beneficial to get an insight into how the committee worked, the volume of information. I mean, I think every night that I was there, I worked past midnight every night, a few hours sleep, then back in the morning. And I was so impressed by the work that the committee members did, particularly also because they're unpaid positions, and there are also people flying in from all around the world as well. I really have great respect for the treaty body members. And I also know that they also come with the best of intentions. So the critiques that I offer are, yeah, of course, with those caveats, but I do think that more can be done. But I think this also should be built into perhaps some of the reflections around the strengthening of the treaty body process that's been ongoing and seems to still be ongoing now. And to the idea that any sort of reform that we bring to the treaty body systems should also look at my recommendations and what we can actually do to make them more responsive and more effective. So I'd like to think that when we're talking about changing the treaty body structures, that we're also doing it with an eye to this cultural sensitivity and engaging with the various stakeholders of the treaty bodies. Perhaps Case can jump in here, but I'm also going to hand the floor over to Anne, I think.
Case, would you like to jump in?
I think Anne just managed to
unmute.
Anne,
Please go ahead.
I don't know who was to go first, but
you go ahead.
Yes, I mean, I do, Julie, I do think that your approach is a very, you recognize, you do make it clear that you recognize, the members could reflect more on this. But it might not come so naturally to them. So, putting these issues in front of them is quite important. So another interesting debate is whether, is it because who predominates on these committees? Because if you look at the Committee on the Rights of the Child, actually Africa is overrepresented on the committee, but I don't necessarily see that coming through in the jurisprudence of the committee. I don't think so. And as I said, even when you push back a little on those things, actually there's some pretty strict, strong line, bright line issues there. I can just say that it's quite complex to be on to try and make decisions with 17 other people from countries all over the world. As you know, it's a process, but it's still very important that these debates happen in there. Maybe one of the worst things about it is that there isn't sufficient time for debate. It's really when we're drafting the concluding observations that these debates happen. And of course, right now, well, we haven't met since January last year in person, so we're meeting online. Makes it even less easy to have these debates, because at least in Geneva, we can do it over coffee or at lunchtimes or, so I think it's, let's hope that the treaty bodies get back to Geneva and get back to being a little bit more in contact with one another so that those conversations can happen. And maybe, Julie, you should consider coming and making a presentation to some of the committees. Certainly our committee does do that. We have lunchtime sessions where we have members of NGOs and academics coming to address us. So that would be a good idea. I think you should do that.
I think Julie's bags are packed for that already, and she will take that up very soon. I want to hand the floor over to Professor Renteln, because she actually has a question that she's had for a while, and she has her hand up. So I'm going to give the floor to her.
Well, I wasn't coming to the question. I was just saying that what I wanted to say that Dr. Fraser's work includes recommendations that the treaty bodies take a broader, more holistic approach to the topics that they consider, but also the argument that the human rights should be incorporated in the work of the social institutions. And I want to make sure that we give some attention to that. In my experience working with police and judges and lawyers, I found that it's a way to introduce human rights in a kind of more subtle way. I'm not coming in with human rights treaties, but I'm dealing with some of the topics that are of concern, and it may turn out that human rights treaties can be part of the conversation. When I was in Utrecht, Professor Zwart had a meeting with people who did administrative law and the inspectors. And I thought it was a very subtle, imaginative way of trying to get people at the local level to think about different kinds of human rights. And so I think one important part of Dr. Fraser's work is taking that kind of approach, not expecting the burden to fall completely to the treaty bodies, although we all, I think, are interested in these sorts of reforms and so on, but also to ensure that the duty to promote and protect human rights is taken seriously by these other institutions. And I did have a question about the interviews, but we can do that separately, Julie. Again, congratulations.
Case, I was wondering if you still had a point on this last question, because I saw you pop up just before I handed over to Alison. So please take the floor.
Well, first of all, congratulations to Julie for the publication of her book. I must say that I do hope that that Julie will go again to Geneva and not only address the Committee on the Rights of the Child, but also all other human rights treaty bodies. There are no other fora in the world where the intercultural discussion on the protection and promotion of human rights is taking place than in the treaty bodies. In a deep politicized form. Of course, politics play a role even in the context of human rights treaty bodies, but they are, I think, par excellence the fora in the world where the debate should be taken further. And I think the recommendations and the policy recommendations that Julie has made could make a big difference in the years to come. And not only, I think, Julie, do I hope that you will go to Geneva to introduce your book once again, but also that the time will come that you yourself will play a role in this, in one of the treaty bodies. And that could be either the Human Rights Committee, the CEDAW, or any other human rights treaty body. Let me stop there.
Fantastic. Thank you so much for that, Case. Julie was recently telling me about how every week she thinks that she's going to get less and less work. But I think the proposition here is that you've only just begun and that you have a great and stellar road ahead of you with a lot of contributions to make. I'm looking at the time, and we have reached the hour, so I do want to stick to the time. It is evening time here, and I know it's still morning time for some of you. So I'm going to wrap this up here and really once again thank our distinguished panel and all the questions that came in. This was really so enjoyable, as I've now reiterated 3 times. Wish we could have done this in person. For those of you who do have a bit of extra time and who want to hang around and maybe ask Julie a question, we'll keep the meeting open for a bit. But for those of you who need to leave, please do so. And I just officially want to close off the book launch, tell everyone that they need to get themselves a copy. I don't know if complimentary copies are a thing virtually, but to please get a copy and stay in touch, obviously, with Dr. Fraser. She has so much information to share and knowledge to share. And I really want to thank you, and I think I speak for everyone when I say to thank you for this great contribution and the effort and the time that you've put into this work. It's really outstanding. So thank you very much.